to appeal the sentence of the court following that sentencing hearing, and you have a right to appeal, and I'm actually expecting an appeal of the court's decision on the suppression hearing issued in this matter. But basically, you wouldn't really have any meaningful right of appeal for the actual conviction itself, other than the suppression hearing perhaps, but your pleas would constitute an admission to those offenses. You wouldn't be able to appeal that admission. Understand that?
Understand.
Does anyone promise you anything or threaten you in order to get you to plead no contest to these 181 charges other than what's been stated in open court today? Does anybody promise or guarantee that you would receive some type of community control or probationary sentence if you entered a plea of no contest to these charges? Are you entering a plea of no contest of your own free will and doing so voluntarily?
Yes.
Mr. Gornall, have you had the opportunity to review with Attorney Hyde all the essential elements of each and every one of these offenses, as well as all possible defenses to each of the 181 charges and the potential penalties?
Yes, sir.
Has Attorney Hyde explained everything and answered all of your questions to your satisfaction?
Yes, yes.
And are you satisfied with Attorney Hyde's advice and representation in this matter?
Yes, sir.
Co-counsel is not listed on this plea document, but you were also represented by another counsel. Are you also satisfied with that individual's advice, counsel, and competence in representing you in this matter?
Yes, sir.
You understand the penalty ranges for each of these offenses?
Yes, sir.
We're going to review the penalties, potential penalties for all 181 charges. And to do that and make that run a little smoother, I've prepared a spreadsheet that outlines the potential penalties for each of the 181 offenses. And I've kind of jumbled those up in that spreadsheet. Is it showing up on the screen, Mr. Chairman?
Yes, sir.
So we're going to go through pretty much by the nature of the count, just to make it a little easier to summarize and make the review process of those potential penalties a little faster. So you understand that with regard to counts 1, 2, 3, 4, 5, 6, 7, 8, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 34, 35, 36, 37, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, 61, 62, 63, 65, 66, 67, 68, 69, 70, 71, and 72. Those are all the offense of illegal use of minor nudity-oriented material or performance in violation of Section 2907.323A1. All of those are felonies of the second degree, and each one of those counts I mentioned could each individually result in a prison term of anywhere from 2 years to up to a maximum of 8 years in prison, with a maximum fine on each count of $15,000. Do you understand that?
Yes, sir.
Okay. And just so you understand the spreadsheet, the maximum fines, the aggregate prison terms, and the aggregate fines are collectively added up in those right-hand columns. And then do you also understand that with regard to count 9, 10, 33, 38, 39, and 64, all of those counts being the offense of attempt, illegal use of minor in nudity-oriented material or performance in violation of Section 2923.02a and Section 2907.32 on the revised code, each of those being felonies in the third degree. The court could potentially impose a prison sentence on each one of those counts, anywhere from 9 months up to a maximum of 36 months, and impose a fine of up to $10,000 on each count.
Yes, Your Honor.
You also understand with regard to counts 73, 74, 75, 76, 77, 78, 79, 80, 81, 82, 83, 84, 85, 86, 87, 98, 99, 100, 101, 102, 103, 104, 105, 106, 107, 108, 109, 110, count 111, 112, 123, 124, 125, 126, 127, 128, 129, 130, 131, 132, count 133, 134, 135, 136, 137, 138, 139, count 140, 141, 142, 143, 144, 145, and 146, and also count 147, each one of those being pandering, obscenity involving a minor in violation of Section 2907.321A5, each one of those counts being felonies of the fourth degree, and each one of those counts subjecting you to a potential prison term of anywhere from 6 months up to a maximum of 18 months, and a fine of up to $5,000.
Yes, sir.
Understand that? Okay. And you understand then with regard to the offenses in counts 88, 89, 90, 91, 92, 93, 94, 95, 96, 97, 113, 114, 115, 116, 117, 118, 119, 120, 121, 122, count 148, 149, 150, 151, 152, 153, 154, 155, 156, 157, count 158, 159, count 160, 161, 162, 163, 164, 165, 166, 167, 168, 169, 170, 171, and count 172, all of those counts being the offense of illegal use of minor nudity-oriented materials in violation of Section 2907.323A3, each of those being a felony in the fifth degree, that the court could potentially impose a prison sentence of anywhere from 6 months up to a maximum of 12 months on each of those counts, and impose a fine of up to $2,500.
Yes, sir.
And you understand, Mr. Gornall, that with regard to counts 176, 177, 178, 179, and 180, that all of those counts constitute the offense of possession of drugs in violation of section 2925.11a, which is a misdemeanor of the first degree, and each one of those counts of that offense could result in the court imposing a jail sentence of up to 180 days and a fine of up to $1,000.
Yes, sir.
And you understand that with regard to count 181, the offense of receiving stolen property in violation of section 2913.51a, a misdemeanor of the first degree, the court could impose potential jail sentence of up to 180 days and a fine of up to $1,000.
Yes, sir.
And you understand that with regard to count 175, which is possession of marijuana in violation of section 2925.11a, a minor misdemeanor, the court could impose a fine of up to $100.
Yes, sir.
So understand, Mr. Gornall, in the worst case scenario, the court would impose the maximum prison time or jail sanction on each of the 181 counts and impose the maximum fine possible on each of the 181 counts. That the total, and then stack those sentences consecutively and total all the fines that you could be looking at in the aggregate, an aggregate prison sentence, worst case scenario, maximum sentence on all counts of 675 years, 6 months in prison, with the jail sentences being served concurrently to the prison sentence, and then total aggregate fines of up to $1,448,600.
Yes, sir.
Now you understand, Mr. Gornall, on this spreadsheet, throughout the spreadsheet, starting back, I think, on page 7, there were some charges, and we started indicating some counts as to potential merge. You understand that there's been some indication that the offenses outlined in the indictment may, for purposes of sentencing, be subject to a merger issue, in which case the state would elect, if one or more offenses merge for purposes of sentencing, the state would elect which charge to proceed on for sentencing purposes. It wouldn't necessarily change any finding of guilt on a particular offense that's not sentenced. But the state would elect which of the merged offenses to sentence on. And based on the information that the court has to date, there could be roughly about 32 and a half years, 32 years, 6 months in prison time that may not be imposed if those sentences merge.
Yes, sir.
And you also understand that at this point in the discussion, at least to the court's knowledge, there may be other merger issues other than what the court's noted. So the aggregate maximum that I noted of the 675 and a half years may be reduced somewhat based on that merger issue. You understand that?
Yes, sir.
But you understand that we're still talking about a lot of years. You also understand that in addition to those large fines, that the court can impose other financial sanctions, in this case including court costs, day fines, the cost of any sanction that the court might impose, and restitution if that were deemed appropriate.
Yes, sir.
And obviously you do have a professional license issued by the state of Ohio, is that correct?
Yes.
Okay, you understand that upon conviction, that certification agency or any state licensing agency would be notified of the conviction that would likely result in the revocation of that license.
Yes, sir.
And to my knowledge, you're not on any felony probation, parole, or community control supervision, is that correct?
That's correct.
And you understand that if you receive a prison sentence on any one of the F2 counts, the illegal use of minor nudity-oriented material performance in violation of section 2907.323A1, just any one of those, that following your release from prison, you'd be subject to a mandatory period of 5 years of post-release control supervision following your release from prison.
Yes, sir.
And you also understand that following your release from prison, you found yourself on post-release control as a result of the sentence in this case. If you then violated the conditions of that post-release control supervision, the parole board could return you to prison for up to 9 months for each violation of post-release control supervision, with a maximum for multiple or repeated violations being limited to 50% of the original prison sentence imposed by the court.
Yes, right.
And you understand, Mr. Gornall, that if you found yourself subject to post-release control supervision, committed a new felony offense while subject to that supervision, you could receive a prison sentence of the greater of 12 months, or the time still remaining on post-release control, so no less than 12 months, as much as possibly 5 years in this case. With that prison sentence being imposed consecutive to any new prison sentence associated with the actual felony offense that caused the violation of post-release control.
Yes, sir.
And you understand, Mr. Gornall, that if the court determined you were qualified or eligible, the court could impose a community control sanction instead of prison for up to 5 years. But if you violated the conditions of that community control supervision, the court could impose greater restrictions or sanctions and keep you on community control supervision, or revoke your community control status and impose each one of these prison terms consecutively at that point in time.
Yes, sir.
And you understand, Mr. Gornall, if you were to find yourself subject to community control supervision at any point in your sentence, for example, if you were initially to be sentenced to prison, but before you completed that prison sentence, you were released early with a portion of the unserved prison sentence suspended on the condition that you comply with certain community control sanctions, then in that event, if you violated the conditions of community control supervision, the court could again impose greater restrictions or sanctions and keep you on community control. Not initially imposed for 5 years, the court could extend that supervision so it would run a total of 5 years. Or again, community control could be revoked if you violated terms, and the suspended portion of the prison sentence could be reinstated and you could be sent back to prison at that point.
Yes, sir.
Mr. Gornall, you have certain constitutional rights, and by admitting or pleading no contest today in these charges, do you understand that you give up certain constitutional rights?
Yes, sir.
You understand, Mr. Gornall, that you have a right to have your case tried to a jury of 12 persons, but by pleading guilty today, you're able to give up that right?
Yes, sir. No contest. Yes, sir.
I'm sorry. No contest. That's right. And you understand, Mr. Gornall, that that you are presumed innocent of these 181 charges as you sit there this moment, and that you have the right to require that the state will not prove you guilty of each element of each one of these offenses beyond a reasonable doubt to the satisfaction of each and every one of the 12 jurors in trial, but by pleading no contest today, you waive or give up that right.
Yes, I understand.
And you understand, Mr. Gornall, that you have a right to face, confront, and cross-examine the prosecuting attorney's witnesses today, but by pleading no contest, you waive or give up that right.
Yes, sir.
And you understand, Mr. Gornall, that you have the right to compel the appearance of witnesses to testify on your behalf so that you can present a defense of a trial of these charges, even if your witnesses have expressed an unwillingness to appear or don't want to be here. You can force their appearance by court order so that you can present that defense. But by entering no contest plea today, you waive or give up that right.
Yes, sir.
And you understand, Mr. Gornall, that you have a right not to testify against yourself in trial, but by pleading no contest today, you waive or give up that right.
Yes, sir.
And you understand, Mr. Gornall, that you have a right to appeal a maximum sentence on any one of these charges, or if the collective sentence exceeded the maximum sentence for the highest level offense. So if you receive a prison sentence of 8 years or more, basically you have a right to appeal that maximum sentence. But you otherwise waive or give up your right to appeal any finding of guilt entered based upon the charges in the indictment and your plea of no contest, because you're admitting to the truth of those charges in the indictment.
Yes, sir.
And you understand, Mr. Gornall, as a result of your plea waiver give up the right to appeal any errors or mistakes that might have occurred during a trial on these charges, because you're waiving your right to a trial and the court will never conduct a trial, then it will lead to those appealable errors and mistakes to occur.
Yes, sir.
And just because with the no contest plea we're deviating a little bit from my normal plea policy, I want to make it clear when I said you waive or give up the right to appeal the finding of guilt or conviction. That's not entirely true in this case, because you are preserving your right to appeal the court's decision and its suppression here. Do you understand that?
Yes, sir.
Okay. And with regard to counts 1 through 181 of the indictment, Mr. Gornall, what is your plea?
I would like to have a plea of no contest, Your Honor.
As to all 181?
To all counts.
The court finds that Mr. Gornall has, in fact, knowingly, voluntarily, and intelligently waived his rights and has entered a plea of no contest to all 181 counts or offenses set forth in the indictment filed in this case. Further finding that Mr. Gornall has entered that no contest plea without any threats or promises, that he has a full and complete understanding of all 181 charges and the penalties associated with those offenses. And I'm further finding that based on his no contest plea and the identification or the assertion of the charges as they are set forth in the indictment and Mr. Gornall's admission to those 181 offenses as they are stated in the indictment, I find that Mr. Gornall has in fact committed all 181 offenses to which he is pleading guilty. The court will therefore, to which he is pleading no contest. The court will therefore accept the plea of no contest to each and every count of the indictment, counts 100, all 181 counts, and enter a finding of guilt as to all 181 counts of the indictment. As I noted, Mr. Gornall, I'm going to order a pre-sentence investigation report for use at your sentencing hearing. As a part of that report process, investigation, you're going to be interviewed personally by the court's PSI investigator. His name is Steve Niedermeyer, and he works for an agency called Oriana House. At some point, Mr. Niedermeyer will contact you for that personal interview. At the time you meet with Mr. Niedermeyer, you need to give him that questionnaire that's gone to Deputy Donahue, but I'll get it to you so you can fill it out, complete it to the best of your ability prior to meeting with Mr. Niedermeyer. If you have access to the information, it asks for you on the cover sheet of that questionnaire to provide documentation. Produce that documentation. Do so to the best of your ability. If you have available to you, you have available. If you don't, you don't. Complete the questionnaire to the best of your ability, and then when we meet with Mr. Niedermeyer, give him that information and then complete the questionnaire. Mr. Hyde, I already have you scheduled here for 8 or 8:30 on December 28th. Mr. Tonelli, you think about 8 weeks would be sufficient time in terms of getting out notification letters and things of that nature?
That's plenty of time.
Mr. Hyde, would you be available to do that at 9 o'clock?
Yes, sir. That's fine.
Okay. Then we will schedule sentencing in this case for December 28, 2015 at 9 o'clock. And terms and conditions of bond will remain in place until then. Any further, Mr. Hyde?
Judge, we could approach.
Okay. Gornall, has been brought to my attention by your attorney, although we covered it in the potential aggregate prison time and fines, I may have specifically left out counts 173 and 174 individually. The aggravated possession of drug offenses in violation of section 2925.1A of the revised code, each of those being felonies to the 5th degree, each of those individually carrying a potential maximum sentence of up to 12 months in prison and fines of up to $2,500. You understand those are two of the offenses included in the plea of all 181 counts.
Yes, sir.
And it was your intention as well when you entered your plea to enter plea to those 2 counts as well.
Yes, sir.
And you understand that even though I missed them individually, they were still factored into the aggregate sentences that I discussed.
Yes, sir.
Okay. You're reaffirming your plea to count. You have no contest with counts 173 and 174.
Yes, sir.
Thank you. Court will accept that plea, specifically counts 173 and 174. Just make sure it's clear for the record. Anything else, Attorney Hunt? Thank you.
No, Your Honor.
Thank you.
The necessary is concluded. Court is recessed. Take that down. We're done with it. Push the button. Yeah. Down. I'll come down. Straight in. No, that's it. You're good. That's it. Take